in the matter of Shanks versus Unilever Plc and others.
Lord Kitchen will explain the decision of the court.
The appellant, Professor Ian Shanks, is an eminent scientist. This appeal concerns an invention which he made while employed by Unilever UK Central Resources Limited, which I will refer to as CRL. CRL is a company in the Unilever group of companies, which I will refer to as Unilever. In June 2006, Professor Shanks made an application for compensation under Section 40 of the Patents Act 1977, on the basis that the patents for the invention have been of outstanding benefit to CRL and that he is entitled to a fair share of that benefit. The appeal raises important questions concerning the circumstances in which such compensation may be awarded and how the amount of that compensation is to be assessed. Professor Shanks was employed by CRL in May 1982 and was assigned to its research laboratories in Colworth. He received a starting salary of £18,000 and a Volvo car. At that time, CRL employed all of the UK-based research staff of Unilever. It was not a trading company and was a wholly owned subsidiary of Unilever Plc, one of the two Unilever parent companies. Professor Shanks's brief was to develop biosensors for use in process control and process engineering, both of which were important to Unilever's business. However, in the summer of 1982, Professor Shanks had the idea of making a new disposable system for measuring the concentration of glucose in blood, serum, or urine. He built a prototype of this invention at home, using components from his daughter's microscope kit and some mylar film, and he used bulldog clips to hold the assembly together. It has since become known as the electrochemical capillary fill device, or ECFD. The rights in this invention belonged from the outset to CRL because Professor Shanks was employed to invent. CRL assigned the rights to Unilever Plc, and then some of those rights were assigned on to other Unilever companies. Unilever filed and maintained patents, the Shanks patents, to protect the invention in Europe and other countries around the world, but had no interest in making and selling an ECFD product itself. Nor did it have any particular interest in licensing the technology. Its main purpose in having patents was to use them to protect its existing commercial activities, and these did not include glucose testing products. In the late 1990s and 2000s, the glucose testing market expanded considerably, and biosensors incorporating the ECFD technology played an important part of this. Indeed, the ECFD technology came to be used in most glucose testing products, and although not essential, it was one that most significant companies in the field were prepared to pay millions of pounds to use. Consequently, a number of prospective licensees approached Unilever directly. In the end, the Shanks patents generated a benefit for Unilever after costs of about £24.3 million, worth about £40 million today. Professor Shanks's application for compensation was eventually dismissed by a hearing officer acting for the Controller General of Patents in June 2013. Professor Shanks appealed to the High Court without success. He pursued a further appeal to the Court of Appeal, but again without success. He now appeals to the Supreme Court. It is the unanimous decision of this court that Professor Shanks's appeal must be allowed. An employee who makes an invention which belongs to the employer from the outset and which has been patented is entitled to compensation under Section 40 of the Act as it stood at the relevant time, if he or she establishes that the patent is, having regard to, among other things, the size and nature of the employer's undertaking, of outstanding benefit to the employer, and that by reason of these matters, it is just that he or she be awarded compensation. The application of this test involves a number of steps, the first of which is the identification of the employer. At least in an ordinary case, the statutory scheme is concerned with the inventor's actual employer. The next step is to work out the size of the benefit to the employer, and for this purpose, Section 41 of the Act is also relevant. This says that the tribunal must consider the actual benefit the employer has gained or may reasonably be expected to gain from the patent. If the patent has been assigned to a connected person, then the relevant benefit is the benefit the employer could reasonably have been expected to gain if there had been no connection. The third step is to determine whether the benefit is outstanding, and here the word outstanding must be given its ordinary meaning. The quality of the benefit, and so whether it is outstanding, is to be judged in the light of the size and nature of the employer's undertaking. But this gives rise to two further questions. What is the employer's undertaking for this purpose? And what is the relevance of that undertaking's size and nature? The correct approach to the identification of the undertaking is to look at the commercial reality, but to do so from the viewpoint of the inventor's employer, and where, as here, the employer operates a research facility for the benefit of a group, and the work results in patents which are assigned to other group members, the focus of the inquiry must be the size of the benefit from the patents to the group, and how that compares with the benefit the group has gained from other patents arising from the work of the employer. As for size and nature, regard must be had to the particular circumstances of the case. For example, the benefit may be more than would normally be expected to arise from the duties which the employer has been paid. It may have been arrived at without any risk to the employer's business. It may represent an extraordinarily high rate of return, or it may have been the opportunity to develop a new line of business or new licensing opportunities. But a tribunal should be very cautious before accepting a submission that a patent has not been an outstanding benefit simply because it has had no significant impact on the employer's overall sales or profits. An essential part of the hearing officer's reasoning was that Unilever had generated a vast income and profits from the manufacture of products such as ice cream, spreads and deodorants, and these profits were an order of magnitude greater than the profits Unilever derived from the Shanks patents. Here he fell into error. He lost sight of a number of important matters: that Professor Shanks' employer was CRL, and that its business was the provision of patented inventions to Unilever, that only a proportion of the sale price of Unilever's products, such as ice cream, could be attributed to patent protection, that the size of Unilever's business played no significant part in securing the benefit it derived from the Shanks patents, and that Unilever could not identify any patent which was more beneficial to Unilever than the Shanks patents. Properly assessed, the benefit from the Shanks patents was outstanding. The rewards were substantial and significant. They were generated without any significant risk. They reflected a very high rate of return, and they stood out in comparison to the benefits Unilever derived from other patents resulting from the work at CRL. What was more, the benefit from the Shanks patents could not be attributed to the use of Unilever's financial muscle or size. Professor Shanks is therefore entitled to a fair share of the benefit Unilever derived from the Shanks patents. That is to be assessed having regard to the wide range of matters set out in section 41(4) of the Act. The hearing officer decided that such a share would be 5% of the net benefit, and no basis has been shown for interfering with that assessment. It is not appropriate to reduce this share to reflect the tax Unilever has had to pay. Unilever can take the benefit of any available relief from tax on the monies it is now required to pay to Professor Shanks, and Professor Shanks will be liable to account for tax on the money he receives. It is, however, appropriate to increase the share to reflect the time value of money. An aspect of the benefit Unilever has derived from the Shanks patents is the time for which it has had the money it has been paid. Correspondingly, Professor Shanks has been kept out of a fair share of that benefit. Fairness demands that this should be reflected in his award. It is therefore the unanimous decision of the court that Professor Shanks is entitled to a payment of £2 million.
Thank you. The court will now rise briefly to reconstitute itself.